proceed, Ms. Holland.
Good afternoon, Your Honors, opposing counsel, and Happy New Year. My name is Josie Holland. I represent the appellant Heath Bell. I'd like to reserve 5 minutes for rebuttal, please. Your Honors, Mr. Heath Bell was denied effective assistance of counsel at every critical stage of this proceeding. His trial counsel failed to protect his client by making sure that the mandatory procedural safeguards allowing the state's most essential piece of evidence to enter to the jury unvetted. Compounding that error is the ineffective assistance of appellate counsel who failed to raise the critical, single, most obvious issue that would have been outcome determinative. In today's argument, first, appellant will discuss the ineffective assistance of counsel of both trial and appellate counsel. Second, we'll discuss the fundamental due process violation that counsel failed to challenge, which serves as proof of prejudice for the ineffective assistance of counsel claims and is preserved as an issue. Time permitting, we'll address some of the state's concerns. Turning to our first issue. Under Strickland, Mr. Bell must show both ineffective assistance and prejudice. Here, deficiency of both trial and appellate counsel is clear from the record. Trial counsel's deficiency is established by his failure to object to the state's improper use of a recanting witness. He failed to demand the trustworthiness hearing under Rule 803-26. In his own petition for post-conviction testimony, trial counsel admitted that he should have requested the hearing and he would have had a compelling argument. That can be found at volume 5, pages 93 to 95. His failure was not strategy. It was a surrender to the most important evidentiary issue in this case. Meanwhile, appellate counsel was equally deficient. In the standards set forth in this court in Carpenter versus State, this requires counsel to raise significant and obvious issues.
Counsel, let me ask you this. I agree that trial counsel testified during the post-conviction hearing that he should have asked for a hearing on the witness statement, the admissibility of the witness statement. I have two concerns here, and I think one of which the post-conviction court talked about, hung her hat on in denying relief, the first being that counsel was asked specifically if he wanted to object to the admissibility of the witness's statement. Counsel was given an opportunity to consult with the defendant, and he wanted the statement to come in. So address that for me first, and then address the fact that the trial court at the motion for new trial hearing even said, even had you objected, there would have been no way he would have denied the state's motion to admit the witness's statement for lack of trustworthiness. There would have been no way he would have excluded the witness's statement, is what I'm paraphrasing, the trial court said. So even if counsel had objected, it would have been futile.
So to answer your question in two parts. First, deference only to counsel's decision only applies if that decision is reasonable in the first place. It has to be a reasonable strategic decision, and this was such a critical piece of evidence that had it not been introduced, it's unlikely that the state's case in chief would have survived a motion for judgment of acquittal. As to...
How do you come to that? I'm sorry, say that again.
How do we come to that conclusion? Because the other proof that's in the case is very weak, right? We have a fleeting nighttime identification.
Well, you have two witnesses who say they saw your client lurking minutes before the offense occurred. Then you have another witness who identifies, or the witness who recanted her statement, the defendant, as running from the scene minutes before or minutes after she heard the gunshots. That's not, nothing. You agree? And then there's cell phone evidence about him being in the there's more than just this statement.
Your Honor, and I never
Yeah.
meant to say that that was just this statement. What I said was there was a fleeting nighttime identification by James Edwards, and there's some discrepancy in the time that he puts himself in the area as to when he says he sees the defendant. And there's the cell phone data, but that places the defendant in the broader area. It doesn't necessarily place him specifically at the point where the crime occurred. But I would, if I could, address your second question that you posited just before that question, Your Honor.
Yeah, well, I thought you were going to the fact that you said it wouldn't have survived a motion for judgment of acquittal, at the close of the state's proof, and that's where I thought you were, and I was perplexed by that comment, but go ahead.
And we do maintain that, Your Honor. The other identification is weak, and the cell phone data is broad. So as to the question of if the trial court was going to deny it anyway, how can we prove prejudice? Well, one of the trial judges, Judge Montesi, at the preliminary hearing, he found that the witness had recanted, and he found that her statement should not be entered into evidence.
That was a prelim. That wasn't a trial.
Right.
I don't understand.
That's not binding, is it?
Certainly, it's not binding at all, Your Honors, but it does demonstrate two different opinions from two different jurists.
Well,
He didn't
but
hear
it
the
does.
proof.
It does, but the trial judge who heard the case is, unless there's something weird happens, is going to be the trial judge who hears the post-conviction. And in order to be successful on a post-conviction, you have to show the likelihood of success should I have raised this at trial. And you have the person who would rule on the post-conviction saying, I wouldn't have excluded it. So what Judge Montesi, with all due respect to Judge Montesi, said in the general sessions is really irrelevant. It's what the trial judge who heard the case said, because that's more likely than not who's going to hear the post-conviction. And he's saying you wouldn't have won this on the merits then, so he's got to be saying you wouldn't win it on the merits now.
And a probable cause determination is entirely different than a full-blown trial.
Yes, Your Honor. As to your question, Judge Dyer, the trial judge's decision has to be reasonable, and it has to be based in law. And even had the trial judge denied that particular issue, appellate counsel still could have taken up the banner and could have been reviewed by this court under de novo. Speaking of appellate counsel, neither complied with Carpenter or Campbell versus State, which finds deficiency when counsel fails to raise an issue clearly stronger than the ones presented, and the improper admission of the state's most critical evidence, and that's Shamir's tally statements, and I don't believe it's explicit in my brief. That is Exhibit 51 in the original trial record. Volume 7 of this record contains the stipulation between the parties that the prior record is part of this record. To establish prejudice from counsel's failures, appellant must show the underlying claim was meritorious. And the underlying claim for constitutional violation here was not just meritorious, it was dispositive. The state's argument that this due process claim is waived is factually incorrect. The petitioner's summation that he provided before the judge ruled can be found at Volume 1, starting at page 57 of the technical record, and it explicitly argues a Fifth Amendment due process violation.
Well, is it included in the order of the post-conviction court? Was there a ruling on it?
No, Your Honor, I believe it was ruled under the Sixth Amendment claim, but in order for us to establish prejudice, we have to show that a constitutional right was abridged. So even if the due process issue is not a freestanding claim, it certainly holds hands with the Sixth Amendment claim, in that because counsel was ineffective for raising the objection, he allowed the due process violation to occur.
I'm sorry. I'm getting a little lost in your argument, so forgive me, Ms. Holland. I may be confusing you, so let's take a breath. Are we talking about appellate counsel?
We are talking about trial counsel.
Okay, and for trial, for the issue that you're saying you're responding to the state's waiver argument, what specific issue is that?
Trial counsel's ineffective assistance in failing to object under Rule 803-26.
Okay,
It,
that's clearly in the order of the post-conviction court. Now,
Absolutely.
your freestanding due process claim, is that in the order of the post-conviction court?
No, Your Honor,
Okay.
and we're not claiming the freestanding due process claim as a separate issue. It merely serves to demonstrate the prejudice under the Sixth Amendment claim. And why is that? Well, this argument's twofold. First, the state's tactic violated the longstanding prohibition from Mays v. State against calling a witness as pretext to introduce a disavowed statement. And that statement was disavowed under oath. Second, the trial court failed in its gatekeeping function, and trial counsel, both through the failure to object and in appellate counsel's failure to raise the issue on appeal, it allowed the court to circumvent its gatekeeping function under Rule 803-26. Again, the state cannot, as a pretext to introduce otherwise inadmissible hearsay, call someone into court.
The state's position, if I understand it, is it's a broader piece of testimony. It's not just bringing her in just to so she contradicted herself. I mean, there's several things in her statement that were consistent throughout and that support the state's theory. There's just maybe more than this, but there's just one or two things where there's the contradiction, but the rest of her statement is consistent to the original statement. The recantation are similar, and therefore, why shouldn't they be able to call her to at least get that proof out?
Well, I must respectfully disagree that her statement was in total, that was otherwise.
It's not, I'm not saying they're mirror for mirror, but I mean, as I understand the state's argument, the state's brief, there were pieces of Ms. Talley's testimony, or her original statement and her second statement, that are completely consistent with one another and consistent with the state's theory.
I agree with Judge Dyer. Timeline, for one,
Yeah.
they were putting her forward to establish a timeline of the gunshots. There were just several other things, and just to kind of elaborate.
Right. Timeline, clothing, and knowing the people involved. Those were consistent throughout. And if that's the case, she is a relevant witness to the state's case. And for all everybody knows, who's to say she's not going to get on the stand and recant her recantation?
Well, Your Honor, first they had to issue a warrant to get her there. Second, the state knew she would recant. That was admitted in Volume 6, page 18. And the other issue with that is that the state, in the post-conviction hearing through the testimony of ADA Sam Winnig, said that their primary theory of the case, the cake of the case, is that they believed that these two sisters, one who had been allegedly dating Mr. Bell and one who had been allegedly dating Joe Harwell, the deceased, that they had set this up in order to rob, as sisters, to rob them. So that requires a couple of relationships to be established, which Miss Shamir Talley had disclaimed. So if the state needs Ms. Talley's statement in order to prove up their most substantial piece of their case, its materiality is undeniable. And simply because there's some congruency in certain places, the state intended to call her, knew that she would give testimony opposite to what she had said to police, and then they substantively introduced this testimony. And that, Your Honors, is a violation of Rule 803-26. Your Honors, Mr. Bell was denied effective assistance of counsel at every critical stage of these proceedings. Your Honors should reverse this matter and remand for a new trial. Thank you so much.
Thank you, Ms. Holland. You have your 5 minutes rebuttal. Mr. Kirby, Mr. May. I'm sorry.
Judge McMullen, I thought that would come more closely from Mr. Dyer, or Judge Dyer, than you. May it please the court. Good afternoon, Your Honors. Kirby May on behalf of the Attorney General's office. this court should affirm the judgment of the post-convictions court because the petitioner has simply failed to prove by clear and convincing evidence deficient performance or prejudice by either trial counsel or appellate counsel. And one thing to direct, I just want one thing, my friend on the other side, Ms. Holland, commented on that the state prosecutor was aware and knew how she would testify, and that she was going to continue to recant. And it was clear from ADA Winnick's testimony at the hearing is they were unsure. They had had no contact with her. They had, it's undisputed, they had to get a material witness warrant. However, even Mr. Burton, who was trial counsel for Mr. Heath, testified that he was unaware and unsure how Shamir Talley would testify.
She mentioned it, and you mentioned it too. Was the fact that they had to get a material witness warrant really have any true bearing on whether or not this is a credible witness, a favorable witness, what disfavorable witness? I mean, just because they may have gotten a warrant because they can't find her, right? Or she's somewhere else, or she's in, I mean, it doesn't necessarily mean, my point is, it doesn't necessarily mean she is opposed to one side or the other.
No, simply she does not want to be involved.
Right.
That's, or is just unable to locate. Those are the two reasons for material witness warrant in my experience. And so really that part is irrelevant. What is relevant is, and also I believe is irrelevant, is that the state was prepared in its preparation, one way or the other, to present, as Your Honor had mentioned, the consistent aspects of her statement, original statement, which corroborated other witnesses, Mr. Jennings, Miss Jennings, and Mr. Edwards' testimony about the clothing of Mr. Heath that was wearing that day, as well as other information. They were in planning to present at least a minimum of those aspects of it. However, as good prosecutors, they were also prepared if it did not go well. And they were ones that approached the court after she had testified to ask for the hearing. They actually, the state was the one that presented the request for the 80326 hearing. And the court at that time reviewed the testimony and evidence that had been presented up to that point from the other witnesses as well as Ms. Shamir Talley, and asked the defense, the petitioner's attorney, whether they wanted to have a hearing. And at that point, he asked for a recess to discuss and review the matter with his client and came back and decided not to seek that hearing. There's no requirement when, even though the statute says that they're required a hearing, if the party does not oppose it, that hearing is not required because they've conceded that issue and went forward with that.
I remember reading that either in your brief or the appellant's brief. What was the advantage for him? Because I understand the trial court really relied on that in its order as its first reason for denying. But in saying it was a strategic decision, what advantage does the defendant get? Because what they're arguing basically is you can't say it's strategic because this wasn't well informed. He didn't know the law. He admitted he didn't know the law. And had he known the law, he would have objected.
That's not what he, in my memory of the testimony and the transcripts, that's not exactly what he testified. He actually testified, this is Mr. Burton, the trial counsel, testified that he was aware of Rule 607 as well as Rule 80326 and considered the aspects of how to handle Shamir Talley's testimony. Again, he wasn't able to locate her prior to trial either, or interview her prior to trial either. And so he was aware and had considered those issues, even up into that point, and had considered and reviewed not only her statements in the discovery, but also her preliminary hearing testimony. So he knew the distinguishing and the recantation, what issues that were recanted. And simply the only issues that were recanted was that Mr. Heath Bell she observed Mr. Heath Bell fleeing the scene.
That's a pretty big one.
It's a pretty big one, but also, that was the sole issue in regard. Everything else, for the most part, was consistent, except for she stayed in the apartment room longer and did not see him fleeing the scene.
I still haven't heard yet what's the advantage. What was the strategy behind not saying no, Judge? The judge said, hey, Mr. Defense Lawyer, you know, this might be a problem. You want to address this statement that's getting ready to come in if you don't object. Literally took time to consult with his client, came back and said, no, Judge, it's all good, let it in.
Well,
Why would he do that?
he was never specifically asked that question, what his strategy was as to letting in. The opposing counsel, the prosecutor, was asked that question and gave a detailed response of he was going to use portions of her statement, as well as co-counsel was going to use portions of their statement to bolster their case about how the statement was given. And those were the aspects that they wanted to use.
But understand what my question is, because it refers back to what's in the order denying relief. The trial court said trial counsel made a strategic decision, okay?
What strategy?
But, and so let me kind of
Yeah.
follow up on both of these, because I have it in my notes here as I'm looking at it, that he made this finding that this was a strategic decision. He wanted to show that the police used coercive tactics.
During the interview process.
So who made that statement?
That was, Mr. Burton just discussed that in his transcripts at the post-conviction hearing. He did testify generally about that. He focused in his cross-examination of her and in the cross-examination of Detective Frias, and I want to say it was Brown. I might be wrong in the second detective. The cross-examination of their tactics used and how they influenced her statement, and that's what he wanted to do. And one thing pointed out by the prosecutors, he might not have been able to present that much information in front of the jury if he had that hearing. Again, there was speculation part of the prosecutor, because this question was not asked of the by the post-conviction attorney of Mr. Burton. And again, this is the petitioner's burden to show by clear and convincing evidence. We may disagree, looking back, hindsight, at his strategy, and it says, but it was a reasonable strategy based on the evidence he had, and it was an informed strategy because he discussed it with his client and reviewed and considered the law. We may, looking back, say it might have been different, or we might have used a different strategy, but that's not the standard here.
So the record's going to bear out, then, to answer our question a little bit deeper, the record's going to bear out that the strategy, whether we like it or not, in 2020 hindsight, was that he didn't object because he could use this statement to point out that police are coercive in trying to get statements.
There was no other statement. I'm trying to follow. I'm sorry.
No,
That's why I'm trying
that's
to
my
get
follow-up, so you're there already.
some more from you. I know that there were multiple grounds that the post-conviction court denied relief here, but the first one was that because the defense counsel, trial counsel, made a strategic decision not to object.
Well, not to object, and he had a plan to use that statement, and he did not object. And he's testified, looking back, and I disagree with my partner, my counsel on the other side, that it wasn't that he thought he had reason. He in his testimony said, I didn't believe that the judge would grant my motion to exclude that testimony or that statement coming in. He testified very clearly he thought that. And again, his appellate counsel, reviewing all the record and the transcript, agreed. And again, and when we talk about appellate counsel, and I'll skip real quickly because I know I only have so much time, appellate counsel looked at all the record and considered everything, and it would have been on plain error. Again, it was not raised at trial. An appeal of that issue would have been under plain error. And she did raise 5 other issues, which she determined, based on her experience, that were stronger issues. And at this issue, on appeal, when not being raised at trial, would have been on plain error. And again, it's the state's position, it would not survive plain error review in regards to that. And so it was not a strong issue. And so appellate counsel was not deficient, and the state's position is that the petitioner was not prejudiced by her decision.
What is your interpretation of their due process claim? Because you had some mention of it being waived in your brief.
So typically due process claims, in my understanding of the law, are raised at trial and on appeal, and they're waived when they're raised on post-conviction. But in addition, the claims raised on appeal were raised for the first time on appeal. They were not raised in the petitions or in the amended petition. And while there may have been a vague reference during the hearing by the petitioner, it was not addressed by the parties or by the court in order. So it's the state's position that those issues, the standalone due process claims, were waived. for multiple reasons.
Okay, I just wanted to be clear. I was understanding what was going on there. Okay.
I'm trying to think of, I think I've covered the issues. If y'all have no other questions, the state would ask you to affirm the judgments of the post-conviction court that the petitioner has clearly failed to meet its burden to show that the trial counsel or appellate counsel were deficient, or that he was prejudiced by their actions. Thank you, Your Honors.
Thank you, Mr. Mays.
Do you hear that too?
I do.
What?
Oh, is that a
feedback?
timer? Yeah.
It's gone now.
Ms. Hollins, you have your rebuttal time.
Shamir Talley was late at night taken to the police officer's station. She was handcuffed, she was chained to a table, and the officer swore at her in a horrible way and threatened to take her children from her. Rule 803-26 is designed to keep evidence that, while it might otherwise be probative, is so manifestly unreliable that it should be kept from the jury's purview. That's why 803-26 is a shall, not a may. And even if appellate counsel had determined that under plain error she might not have succeeded, had trial counsel properly made his objection, even if it was just for the sake of the record, he still could have employed whatever technique he wanted to talk about the police being bad. But the fact remains that this was a coerced statement, and whatever it may line up with on the stand is indicative of how the government came at Ms. Shamir Talley full power, and she was alone, and she was afraid for her kids. And even to get her there, they had to arrest her for trial. The due process, Fifth Amendment due process, that's in writing in the petitioner's summation. It's not briefly mentioned verbally. The claim of ineffective assistance of counsel is the specific constitutionally recognized vehicle that overcomes the state's argument for waiver. The very purpose of post-conviction relief is the very basis of an ineffective assistance of counsel claim. If you were to argue that we cannot now say that ineffective assistance of counsel led to a due process violation, ineffective assistance of counsel is appropriately brought at the post-conviction stage, and any kind of waiver that this court might decide would render the Sixth Amendment meaningless in terms of post-conviction relief. The fact remains is that Mr. Heath Bell received ineffective assistance of counsel. He did not have the mandated 803-26 hearing to determine the trustworthiness of the statements contained therein, and because he was denied that, it violated his substantive due process rights. Your Honors, the basis on which these convictions stand are unconstitutional. We would urge the court to reverse and remand. Thank you.
Thank you, Ms. Hollins. Thank you for the briefs. Thank you for your argument. The matter will be taken under advisement. I think this concludes, one more? I am